Welcome back to my channel. I'm Advocate Manjit. In today's video, we are going to talk all about bail, what is a bail and how exactly a bail application needs to be drafted. So before we start with what is a bail, let's try to understand the different kinds of offenses that you have. So the offenses can be categorized as a non-bailable offense as well as a bailable offense. So section 2 of CRPC defines bailable and non-bailable offenses. So a bailable offense is that which is not of a very serious nature, and getting a bail is the right of the accused. If I have to give you examples of bailable offenses, it could be defamation, it could be forgery, it could be giving false information. So these are some of the offenses which are bailable offenses. And what exactly would be non-bailable? Well, the ones in which bail is not given to you as a matter of right are non-bailable offenses, offenses which are of a very serious nature. For example, like murder, you have dowry death, you have rape. So these are some examples of offenses which are non-bailable offenses. So this is in short what is bailable and non-bailable offenses. So now what is a bail? So bail is basically releasing the person who is arrested, releasing the accused on certain terms, certain conditions, or maybe on providing a certain security. And the provisions for bail are section 437 and 439 of CRPC. Now there's another kind of bail which is anticipatory bail, wherein you can apply to the Sessions Code or the High Court under the provisions of section 438 of CRPC, where the accused is apprehending certain kind of an arrest. So before you actually get arrested for an offense, and if you're apprehending that you might get arrested, then yes, you can apply to the Sessions Court or the High Court for an anticipatory bail under section 438 of CRPC, and it may or may not be granted to you. Now we come to how exactly a bail application needs to be drafted. So the bail application would start with the name of the court, the name of the magistrate court where you are putting forward the application. It could be a Sessions or a High Court as well if it's an anticipatory bail application that you're giving. Then you have the section under which you are applying for the bail. You have the name of the parties, you have the name of the police station where the accused is held under arrest. Then you have the date on which the accused has been arrested. And now you would have to specify the grounds on which you are applying for bail or seeking bail of the accused. So it could be like he's a good citizen of the country, he's a respectable member of the society, there is no involvement of the accused in the offense, or probably a case wherein you can also try to say that the offense or the case is of a civil nature and it's portrayed to be a criminal case, or you can mention things like the case is bogus itself, the accused is falsely implicated in it, he belongs to a respectable family, a good family. Then you can also say that he has XYZ health issues, or probably he's the sole owner or a bread earner of the family, he has good antecedents, he's the only earning member of a family of maybe 6-7, have old parents, a pregnant wife. So any reason, any ground which supports the release of the accused can be mentioned under grounds on which you are asking the court to release the accused on bail on certain security or terms and conditions. Now after the grounds, you would also need to specifically mention that your client, or the accused rather, undertakes to be present during all the court proceedings, would cooperate in the proceedings, would be present if called for any investigation by the police officials, he would not tamper with evidence, he would not leave the country, abscond the country, or he would not threaten the other witnesses in the case. So this is all he has to give in writing in the bail application itself, and undertake that he would cooperate throughout the entire proceedings in short. So after this, the last thing that you would mention in your bail application is the prayer clause, wherein you are asking the court to release the accused, your client, on any terms and conditions or on a security bond as the court deems to be fit, and also asking for any other relief that the court thinks is fit in this particular case. So after the prayer clause, of course, the advocate will sign, and at the same time, you will have to take the signature of the accused as well on the bail application, because he's asking bail from the court. So this is in short how a bail application needs to be drafted. Similarly, you can also draft an anticipatory bail, bearing in mind certain changes that you will need to make in an anticipatory bail. So, for example, the name of the police station, the date on which the accused has been arrested would not come into picture in an anticipatory bail for reasons that the person is not arrested already. But yes, in an anticipatory bail, you will have to convince the court why exactly your client is apprehending arrest. What exactly is the need for him to approach court to give him an anticipatory bail? What makes him think that he's probably going to get arrested? And also the section under the anticipatory bail needs to be applied is of course different, which is section 438 of CRPC. So that's how you can go about drafting an anticipatory bail as well. So this video gives you an idea how you can start with the drafting of bail applications and anticipatory bails. So just guidelines on which you can work to successfully draft a bail or an anticipatory bail application. So that's all in this video. Do like, share and subscribe to my channel to keep me motivated so that I bring in more videos for you guys. Also press the bell icon to receive notification of my next video. I'll see you all in my next video. Till then, keep learning.